All right, good morning, everybody. Ready to go?
We're ready, yeah.
Yes, Your Honor.
All right, looks like we're going to do Johnson and then Loomis. You can go ahead and let everyone in. Okay. All right, what's the state feels appropriate?
Thank you, Your Honor. For this defendant, the state's seeking $100,000 with no 10% cash alternative. We're asking for DAS supervision along with a no contact order with the victim. We are also asking for no firearms or weapons, as well as house arrest and GPS prior to release. That is based on several factors. Number one, the underlying violence outlined in the probable cause declaration. In addition to the defendant's very high MPRA score of 13, you can see he got the maximum number of points for prior violent criminal convictions. He was paroled from his last felony in March of 2024. That was a DUI third out of our second judicial district court. When I pulled the pre-sentence investigation from that case, showed him to have 2 felonies and 22 prior misdemeanor convictions. 2 of those misdemeanor convictions were from 2022. They are those prior domestic batteries that were discussed in the probable cause declaration. One was out of Sparks Justice Court, or it looks like they were both out of Sparks Justice Court. He had issues with being out on bail in that case. Looks like he was revoked no less than 3 times on those cases. In addition to that, he has a DUI, and it is this, I think, also mentioned in the probable cause, same victim as we see here. He had a misdemeanor DUI in 2019. He was released on supervised bail. It was later revoked. He was given probation on that case. It was also later revoked in 2020. He has misdemeanors for trespassing and destruction of property that year, another DUI in 2017. He's got a felony conviction in 2014 for intent to utter a fictitious bill. He received diversion on that case originally. He was removed from diversion and sent to prison on that case. And then he's got another misdemeanor conviction for domestic battery in 2012. He has a assault conviction out of Reno Justice Court in 2011, along with possession of drug paraphernalia. And then finally, another assault conviction back in 2007. We were able to speak to the victim, who I believe is present here today. She said she is not seeking a no contact order, and that she is not in fear of the defendant. She said he's a great guy with a really good job and a good provider. She says he doesn't have any weapons. But unfortunately, I disagree with the victim. We are asking for a no contact order based on the safety of her and her children. This, as you can see from the probable cause declaration, the victim was somewhat hesitant to report what happened in the first place. We know one of the children came forward and reported to police that the defendant had struck the victim in the face, and that she had injuries as a result of that. So based on his criminal history, his compliance issues, and obviously the violence in this case, we do believe a higher bail is appropriate and are seeking that $100,000 with those conditions.
All right, thank you, defense.
Judge, that would be a de facto hold on Mr. Johnson. We're seeking for an OR release in this case, maybe $5,000 bondable. This is one of the rather strange PC in that it seems that there was a fight earlier in the night in which other women jumped the victim in this case. And there was an argument between Mr. Johnson, and this is all in the PC sheet, and her about what had happened and whether or not he had let it happen or seen it happen. And the officer notes that the victim is actually striking him in the face when the officer sees her. He actually witnesses that event. I understand that the children may have seen something or may have seen her after or heard something. I'm not clear about that yet. This really looks like a case that needs to kind of go to trial and get figured out. But in the meantime, I don't think Mr. Johnson should be held in jail while we figure out what actually took place in this case. I understand the state can proceed on charges without her wishes or beyond her wishes, or against her wishes, that is. But given that he's been here for 19 years, he's got a job, he's got kids in the area, we're asking for an OR here or $5,000 bondable. He's not a threat to run. Although he has a history of violence, he does not have a history of taking care of business. He does show up to court and he will do as directed. We're not opposing any of the conditions as set by the court or as requested by Ms. Casso, Chief Casso, excuse me.
All right, let's go ahead and hear from the victim. Just go ahead and unmute yourself and you can let me know what your thoughts are. If you're having problems, go ahead and chat my clerk. Otherwise, we're gonna have to move on.
Hello, can you hear me?
I can hear you. Go ahead. What would you like to say?
Hi, Your Honor. Good morning.
Good morning.
So this whole situation, it's it really is a real misunderstanding. I understand, like, I don't know, it kind of hurts me, like, they're bringing up his past and, like, looking at his past and stuff, but Deontay's been doing really, really good, like, very good. He's been staying out of trouble, staying out of way. He does have a really great job that he end up receiving. And if he doesn't get to work, like, we will even lose our home because we had just moved. He has never, ever put his hands on me at all. And with the whole situation that happened, it didn't even happen here in the house. And it had nothing to do with me and him. I locked him out. I was upset. You know what I mean? And I was more of like the aggressor, and, you know, we were bar hopping and things took place with somebody else. And I told them that, and I don't understand what is happening or why it's happening. And it does hurt because I know the truth, and I know that that's not what happened. And he doesn't deserve it, to be honest. He's really great to me. He's really great to his children, my children. He's very enrolled, like, with the football, the travel team, just his kids. He's wonderful, and he's changed a lot, and he's trying to do the best that he can and staying out of trouble. And we just happened to go out one day, and end up getting into a situation. Well, I did. So I just asked, I'm not scared. I'm not in fear. Neither are my kids. Everyone's just really upset. I was upset, and I do apologize, you know, especially to Deontay. Like, I hate this for you, and I just don't want to see him in trouble for something he did not do.
All right, thank you. Thank you for being here. I know this puts you in a very difficult position. I wasn't there. I don't know what happened. I'm in a position to take a sworn declaration from a peace officer who was there, whose job it is to investigate. And we don't, you know, blindly accept any statements made, but that's the evidence I have today, and it does support probable cause for this offense. The next decision I have to make is whether or not the state has shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. And I know it bothered you to hear the prosecutor go into detail about his prior criminal history, prior crimes of violence, prior failures, both on crimes of violence and driving under the influence charges with our courts. And you believe he's a different man than what that history portrays. But all the science says the best predictor of future behavior is past behavior. And so he will have an opportunity to make a new history for himself. And once these things get further away from him as far as years in his criminal history, then courts will not use it against him. But right now, these are the greatest predictors of what he's likely to do. And again, I know it's a different person than what you say you know. But I have to go with what the evidence suggests to me in this case. And so
please don't do this. We're going to lose everything. Like, I understand. I'm sorry. I'm not trying to talk over you, Your Honor, but I know, like, this is the thing. And this is the thing with the system, because I am myself of a person that has a past, and I have changed my life around. I got my record sealed. He has changed. He's not who they even saying he is. It's not. I promise you. He has an opportunity with a great job. He goes to work every day. And if he doesn't even go to work, he will lose his job. Then what? It kind of puts him in a situation. I don't want that for him. Or for us, we could lose our home. I'm begging you, and I swear, this is not what happened. It's not what happened. Please just take mercy and just at least a trial. Okay, whatever we got to do. He will not run. You can't judge. Please don't judge. Give him a chance. Please.
So I believe in chances. I believe in second chances. I believe in third chances. And the hardest part of my job is either on the civil side, kicking people out of their home, or on the criminal side, putting someone in jail or keeping them in jail. Because I have done a lot of research, received a lot of education on the collateral consequences. I was just reading this weekend on best practices on these types of cases, and this very situation that often occurs where the victim is re-victimized by the financial hardship caused by incarcerating the breadwinner. And so while I've never been in your shoes, I have done everything I can to try and appreciate the situation that you're in and the consequences of my decisions. Luckily, the law says that incarceration is the last resort. And so it's consistent with what, my personal feelings are in this situation. But we use a scoring mechanism so that the judges are not, subjective. We're not going on our fears of, and that objective tool indicates that the defendant has at best a 50 percentile of being successful.
More than that. More.
In this case. I know that's what you think, and that's great that he's got somebody supporting him, but that's not what the evidence says. And then I don't have any evidence that's been presented to me in this case or in all the years I've been doing these cases that shows that any of the conditions available to me will minimize that risk. And so I have no choice in this matter but to set bail outside the defendant's ability to make it. It'll be set at $200,000. No contact.
Oh my God.
Separate criminal offense pursuant to NRS 178-4845, the maximum 120 days, firearms.
That is the problem with the system.
December 1st at 9 a.m. Bail laws, no court hearings.
John, what is the bail?
24 hours being released.
Loomis and then Madsen?
Upon being released, you have to make contact with DAS. Sign right here.
And sir, just so you know, DAS will be gone if you do post that bail by January 1st. So you'll be checking in with this court for your court dates. Thank you. Loomis and then Madsen.
Well, Loomis.
Mr. Loomis has cases. Yeah, Loomis and then Madsen.
Loomis. No. Loomis? No. Okay.
He
waived.
All right. He doesn't have an attorney, so he declined to apply for the public defender. So what's the state feels appropriate as far as bail?
Your Honor, we're seeking 15.
Stop talking.
Sorry, say it again.
The state is seeking $15,000 on each of his 2 probable cause declarations. That's based on his high risk assessment score of 12. For once, I actually agree with the court in this case because the defendant will not comply with any conditions. So I'm not asking for any conditions other than the money bail. He was convicted in Reno Municipal Court in 2024 of possession of drug paraphernalia. In that case, he failed to appear at his community court hearing. He later, upon conviction, got probation with a bunch of conditions to try to help support him. He was not successful there, and his probation was revoked in November of 2024. In 2023, he had possession of drug paraphernalia conviction. Again, this time he was afforded specialty court in this very court, in Reno Justice Court. He was removed from that program in 2024. He had numerous violations during his time in that specialty court. And then he has misdemeanor history almost every year in the 22, 21, 20, 2018. He has a felony conviction for larceny from a person where he originally got probation. It was later revoked. He has a 2013 felony conviction for burglary and a conviction for carrying a concealed weapon that same year. So based on his criminal history as well as his high risk assessment, we're asking for $15,000 on each of his cases.
All right, that'll be the order. December 1st, 9 a.m. is the next court date for the filing of criminal complaint. Obey all laws, make all court appearances, or the only conditions. Thank you. All right, Madsen and then Melgar.
Madsen waived, Your Honor. He's going to hire his own counsel.
Hire his own attorney. What does the state feel is appropriate on this matter?
Your Honor, we're seeking $10,000 on this case, and again with no conditions. Do you want me to go into the reasons why?
Yeah, I think it's safest for the record, so I can still make the finding despite the defendant not being here today.
Defendant scored a 12 on the risk assessment, very high, with 2 points for prior violent convictions as well as 2 points for failure to appear. Arrested. The defendant has a very lengthy history. Within the last year, defendant has had several cases of battery, destruction of property out of this court, which was dismissed due to competency issues. And obstructing and resisting this year, that was also dismissed out of Reno Municipal Court. The defendant does have convictions in 2024 for disturbing the peace, reduced from indecent exposure. It's got various FTAs coupled with her misdemeanor arrests. Another conviction in 2024 for trespassing and possession of drug paraphernalia. Battery conviction in 2023, battery in 2022, and another disturbing the peace down from indecent exposure in 2021. So based on that criminal history, as well as their high NPRA, the state believes the $10,000 is appropriate.
All right, that'll be the order with obey all laws, make all court appearances as the only conditions. December 1st at 9 a.m. is the defendant's next court date. Melgar and then Sheridan. All right, what does the state feel is appropriate in this matter?
Your Honor, on Mr. Melgar, the state's not going to object to an own recognizance release. We see that he scores a 6 on the risk assessment. Obviously, this case is older, over a year old. And I don't show any conviction since 2019 where he had a misdemeanor out of Reno Municipal Court on a false statement to obstruct. So based on that, and unfortunately, we didn't have any contact information to contact the victim, and I don't see us getting any in the time allotted. So the state's ready to proceed, and we are recommending that own recognizance release. We would ask for a no contact order as part of his conditions with the victim.
All right, any objection from the defense?
None.
All right. So, sir, you're going to be released on your own recognizance, no contact with the victim. You're not allowed to possess any firearms because this is a domestic violence case. I will let you know you need to show up tomorrow at the Reno Justice Court. We're on the river, 1 South Sierra Street. You need to show up by close of business at 5 p.m. tomorrow. Let us verify your contact information because we'll be texting you your court dates and information like that. Okay, so just show up at our court tomorrow by 5 p.m. so we can give you that information, and then we will also provide you through that process your next court date. Okay. All right, make sure you show up or a warrant may issue for your arrest if you don't show up tomorrow by close of business 5 p.m. Okay.
Yes, sir.
All right, Reno Justice Court, 1 South Sierra Street. Thank you.
All right, thank you.
Sheridan needs to be trailed.
Sheridan, and then
We're going to ask to trail that matter, Your Honor. Judge,
all right,
we're going to ask
Atalano and then Grimsley.
What does that mean?
I mean, you're gonna sit there until the one of it, man. So just wait, see the last one.
All right, what does state feels appropriate on this matter?
Your Honor, the state is seeking $75,000 along with DAS or pretrial supervision with testing for controlled substances. Again, this is a defendant who scores very high on the risk assessment at a 13. He did have an outstanding bench warrant for a traffic offense. It's from 2023 when he was arrested on this case. We know that he was just convicted in 2024 of possession of drug paraphernalia. That was out of Reno Justice Court. Upon his release, he never checked in with DAS as ordered. He then failed to appear and a bench warrant had to be issued for his arrest. He's got that citation out of Reno Municipal Court where he failed to appear at arraignment and a bench warrant had to be issued for his arrest. That's the current warrant. 2021 felony conviction for sales and transport of a controlled substance out of our 2nd Judicial District Court. He received a prison sentence in that case. He did have pretrial violations during the pendency of that case, which included a bench warrant having to be issued for his arrest. He was actually given an opportunity in that case to go to Salvation Army, seek treatment. He apparently used controlled substances while he was in that program and got kicked out, and then he ended up going to prison. He suffered a conviction for obtaining and using the personal identifying information of another that same year in 2021, which he also was sent to prison on. He has convictions for obstructing and resisting in 2020, possession of drug paraphernalia in 2019, a DUI in 2018, and then felony convictions for possession of a controlled substance in 2013 and 2 in 2004. Those were all out of California. He's got another felony conviction for embezzlement in 2004 and then various misdemeanors. So the defendant clearly has some significant substance abuse issues throughout his criminal history as well as now. So the state believes he is a risk not to appear or comply with this court's order, as well as continue to use controlled substances. So the state believes the $75,000 with the previously asked for conditions would be the appropriate bail.
All right, thank you. Defense?
Judge, he does not have a history of violence per that NPRA. I understand he scores high, but we were able to confirm a residence and a job. That breaks his 13 down to a 10. And again, that still remains high, but given the nature of the facts of this case, he's got no license plate, and that's why he gets pulled over. He's not causing a lot of trouble. He's not bringing attention to himself from the police. And then it turns out he's got some drugs in his car. So given the nature of this case in particular, and because he's got a job and a place to stay, we're asking for an OR in this matter.
It wasn't my car.
All right. Thank you. The state showed by clear and convincing evidence that bail, even outside the defendant's ability to make it, is necessary to ensure the safety of the community and the appearance of the defendant. I have not received any least restrictive means that would reduce that risk that have been proven effective. And so I must set bail in this case. At the amount requested, $75,000, or bail laws make all court appearances December 1st at 9 a.m. The other conditions requested by the state are not supported by the evidence sufficient to overcome the significant restraint on liberty that they cause and the least restrictive means analysis required. We'll see you December 1st at 9 a.m. Bail laws make all court appearances. Thank you. Grimsley and then Pulliam Banks. All right, what was the state feels appropriate?
Your Honor, Mr. Grimsley's case, we are asking for a one-day continuance in order to comply with Marcy's law.
All right, sir, we'll see you tomorrow. Thank you so much. Pulliam, Banks, and then Sheridan.
Judge, may I have a brief moment?
Feels appropriate on this matter.
Judge, may I have a brief moment?
Sure, of course.
Oh, I have to be a school.
Thank you, Judge. We're ready.
I have school tomorrow.
All right, the state feels appropriate on this matter.
Your Honor, same thing on this case. We don't have contact information for the victim, so we are asking for one day in order to make contact with her pursuant to Marcy's law.
All right, we'll see you tomorrow, sir. Thank you so much. Sheridan.
Marcy, can you cut and paste those in?
I'll go here. No.
Till tomorrow. You got to have the hearing tomorrow. Because they need contact with the victim.
Sheridan. All right, what does the state feels appropriate?
Your Honor, state seeking $50,000 with no conditions for Mr. Sheridan. Again, as you can see, very high on our risk assessment at a 14. He was refusing to refusing to leave Renown after being told to do that for several times. He's already been trespassed out of there. We know that he has a trespassing citation currently pending in Reno Municipal Court, or he has 2 different trespassing citations pending in Reno Municipal Court. They're both pending arraignment at this point. He's got convictions for obstructing and resisting. In 2024, he was convicted of this exact same offense, sex offender failure to register, out of the Second Judicial District Court in 2024, as well as another misdemeanor for failing to register as a misdemeanor. He's then got a felony conviction for failure to register as a sex offender in 2023. He has arrest out of, looks like, Las Vegas in 2021 for failure, or an ex-felon in possession of a firearm, but there's no disposition for that offense. And then he's got a 2018 felony conviction for attempted sexual assault out of the 8th Judicial District Court. He received a 48 to 120 month prison sentence in that case. Obviously, that is the case in which he has to register for. He did receive subsequent parole violations after being released from that case. Looks like sometime around 2021, he had a parole violation. His lifetime supervision started on that case, which tells me that he was released from prison on February 16th, 2022. So significant amount of time in prison on that case. And then he's got a felony conviction for robbery back in 2004 out of New Jersey. So based on that serious history, his serious underlying conviction for which he must register for, and then not being in compliance, the state believes that the $50,000 is appropriate.
All right, thank you. Defense?
We're going to submit it, Your Honor.
All right, state shown by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and appearance of the defendant. And I've not been presented with any least restrictive means that would mitigate that risk. Therefore, that will be the defendant's bail, and the bail laws make all court appearances December 1st at 9 a.m. to the defendant's next court date. Anything else up at the jail?
I don't believe so.